Good morning, everybody. We begin the second day of evidence in this part of Tranche 3. Those with recording devices may use them to tell the outside world what they have heard in the proceedings after 10 minutes have elapsed, but they may not use them to record or to photograph. May the witness be sworn, please.
Sorry.
Just repeat after me. I swear by Almighty God.
I swear by Almighty God
That the evidence I shall give.
that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth. Thank you.
Please sit down, Mr. Gunn. If at any stage during the evidence that you're giving you need to rise for a moment, do not hesitate to say so. I will rise immediately.
Thank you, sir.
Yes.
Thank you, sir. Mr. Gunn, thank you for coming to give evidence today. As the Chair has said, do please ask for a break if you need one. We will aim to break in any event at around 11:15 this morning. As I know you're aware, there is a list of ciphers in front of you on a sheet. Some people, officers and civilians in this inquiry, have anonymity. If you are concerned about revealing a name, please do just refer to that cipher list in front of you. You also have a copy of your witness statement in hard copy in front of you, but it will be brought up on the screen if you're to be asked about any particular part of it.
I don't seem to have a list of ciphers here. Okay.
They'll bring it over to you if you need it, I'm told. Thank you. Mr. Gunn, you've provided a witness statement to the inquiry dated the 31st of October 2024. Sir, it's at MPS 0749634 at tab 1 of your bundle. Mr. Gunn, is that statement true, accurate, to the best of your knowledge and belief?
Yes, it is, but I think it might be helpful to the inquiry to say how I approach making that statement, which I found quite a difficult task, bearing in mind that I made the statement a year ago. It was about events some 30 or 40 years ago. And as you know, the inquiry asked me 221 questions, of which I tried my best to answer each one. And there was documentation, reams of documentation to check. And I approached it in three ways. The first, looking at the questions, those questions that I recognised and could remember and answer honestly and truthfully without referral necessarily to the documents. There was a second tranche of questions that I did not immediately recognise from my own memory, but in looking at the documents and referring to the documents, I was able to jog my memory and answered as truthfully as I could with that. And then sadly, there's a third category, and this is a category that's troubled me. There are some of those questions I just cannot answer. I do not recall some of the incidents, the events and the persons, and even checking the documentation, and there was mass of it, I still couldn't answer honestly the question. So I put that before the inquiry now, because I've no doubt you're going to ask me a number of questions later that I possibly can't answer.
Thank you for that. Yes, that's understood. In relation to the making of that statement, did you speak to any other Metropolitan Police Service officer or former police officer who is a witness in this inquiry about your evidence?
No, not at all. And if I could just explain, I was a coordinator of a group of former senior Metropolitan Police Special Branch officers. That group, of which there were 15 of us when we started, sadly there's only 7 left, that group was formed, and I coordinated it, to help this inquiry with factual information of the background to the SDS. Under no circumstances did we collude in any way, shape or form on the evidence presented or would be presented by potential witnesses. And I remember and recall having a conversation with the first solicitor of this inquiry, Piers, I think, about those matters, and made it absolutely clear that whatever we discussed in terms of former colleagues, it was not about the evidence, it was about process, facts and help.
I'm grateful. Have you spoken to Mr. Peter Phelan about the contents of your witness statement in its preparation?
No, I keep in contact with Peter Phelan because we're close colleagues and friends, but under no circumstances would either of us talk about the evidence, and we were absolutely sacrosanct in making that distinction when we spoke to one another. We're friends and former colleagues, but under no circumstances did I include in any way talking about the evidence that either he or I give.
Thank you. I just want to ask you about one particular aspect of your witness statement. It's on the topic of knowledge of deceitful sexual relationships by undercover police officers in their cover identity. You and Mr. Phelan were asked a number of questions about that, and I should note for the inquiry's part that those questions were identically worded to both of you. You answered those questions at page 51, at paragraphs 131 to 133 of your witness statement, and he did so, sir, for your note at page 49, paragraphs 144 to 146 of his witness statement. It's at tab 13 of the supplemental bundles, MPS 0749627. Those three paragraphs in each of your statements are very similarly worded. Indeed, the middle one of each is identical, save for one word. Given what you've said just now to the inquiry, can you explain how that came about?
Yes, well, I'm not surprised that there's a similar answer to the same question, but I refute entirely any suggestion that myself or Peter Phelan colluded with that answer. If it's come out looking similar, that's because the question was the same.
Thank you. Mr. Gunn, your witness statement is given in the name of Ben Gunn, but your full name is Dennis George Gunn. Is that correct?
That's correct. I'm commonly known as Ben. The only person that calls me Dennis is my mother, and she's been dead 25 years.
Yes.
But I do sign official documents, DG Gunn, as you will see from a number of my statements, but I'm colloquially known as Ben.
I'm very grateful. You served as Commander Operations in the Metropolitan Police Special Branch from January 1988 until November 1991. Is that right? Your career prior to becoming Commander Operations, you tell us in your witness statement that immediately beforehand you were Detective Chief Superintendent in charge of R Squad, which dealt with policy matters. What type of policy matters in brief terms?
Well, general issues affecting Special Branch and the Metropolitan Police in respect of policy, communication, statutory powers, etc., etc. It was very much the policy hub of Special Branch at the time, and I can't remember how long I had there. I had a year and a bit, I think.
You say that you were posted to Area 6 as a uniform chief superintendent between 1986 and the end of 1987, so immediately prior to becoming Commander
I'm
Operations.
sorry, I didn't get that.
You say that you were posted to Area 6
Yes.
as a uniform chief superintendent
Yes.
between 1986 and the end of 1987, so immediately before becoming
Correct.
Commander Operations. In the early 1980s, were you also a detective chief superintendent?
I must have been.
As Commander Operations, you tell us at paragraph 6B of your witness statement, you were operationally responsible for the Special Demonstration Squad, or what we know as the SDS. Is that right?
That was one of my duties.
Yes.
But I think it's worth pointing out that as Commander Ops, I had a range of duties covering the operational effects of all of the Special Branch work, not just the SDS.
Yes, absolutely. You say that Detective Chief Superintendent S Squad was responsible for the SDS and reported to you, and during your tenure, those were 4 different people: HN 84 Raymond Parker, HN 103 David Smith, HN 115 Anthony Waite, and HN 593 Robert Potter.
Correct.
Is that right? The SDS moved to C Squad in the second half of 1988. Do you recall that?
Yes, I recall vaguely that. It did, and obviously the paperwork substantiates that. And the rationale behind that, I think, is because the main product of SDS work at that time was going to feed into C Squad, which was extreme left-wing activity. And so it seemed logical to put the logistical command and operations of SDS under C Squad rather than S Squad.
I'm grateful.
But I think it moved back subsequently.
Yes. You succeeded HN 587 Mr. Peter Phelan in your role as Commander Ops and preceded HN 294 Donald Buchanan as Commander Operations. Is that right?
Yes, that's correct.
And Mr. Phelan was promoted to immediately above you as DAXO Security.
Correct.
So Deputy Assistant Commissioner, Specialist Operations Security, which I'm going to, for reasons of brevity,
Correct.
refer to as DAXO-S. I'm grateful. You say you were responsible to him and throughout this time, and you met daily with him together with Commander Administration, Don Buchanan, and Commander Anti-Terrorist Branch, George Churchill Coleman. Is that right?
Correct. We used to meet every morning at 10 o'clock to discuss matters affecting each of the squads in Special Branch plus the anti-terrorist branch.
Yes. Would all of those senior officers have known about the SDS as a unit at that time?
Well, they would at that time, yes, but it's worth bearing in mind, as I'm sure you know, that the secrecy of the SDS and the need to know, most Special Branch officers did not appreciate the full remit of, or the existence of the SDS until they reached commander rank.
Yes, thank you. Peter Phelan as DAXO-S at that time, and who had previously been Commander Operations, would certainly have known about the SDS and its deployments upon his handover to you as Commander Operations. Would you agree?
Yes.
What sort of thing, if you can recall, did he pass over to you in terms of the knowledge of what the SDS were doing at that time?
Well, bearing in mind we'd worked closely in adjacent offices for years before it, I had known Peter Phelan for some 30 years before, and so we'd merged our careers in terms of experience over that time. There wasn't a great need for a specific briefing moving from Commander Ops to DAC or backwards in respect of Peter Phelan and I. We knew one another well, we knew the jobs, we knew the remit of those jobs, and we knew how far we needed to cooperate or deal with it individually.
But specifically about his knowledge at that time in handing over to you as Commander Ops and becoming your line manager effectively as DAXO, about the SDS and its operations.
Yes. Well, I mean,
what was the sort of information you received?
We were next door. If there was any concerns, we would speak at any time. But obviously there were some issues that would be delicate in respect of the sensitivity of S Squad. And I've no doubt, well, I can't recall specifically, I have no doubt that Peter Phelan briefed me on that. And if he didn't, I would probably have asked.
But you don't recall specifics
No.
now? Would officers above DAXO have also known about the SDS? do you think you were aware of allegations of criminality against Mr. Scott, or would you have been if there were such allegations?
I should have been if there were any allegations live at that time, but I can't help you because my memory doesn't cover this particular case, and it's troubled me.
No. There was reference in these minutes to an adverse AQR on DC Stephen Scott, which had been served upon him, and that was part of the reasoning, clearly, for his removal from SDS duties. Do you think that an awareness of criminality in addition to that adverse appraisal could have been a reason you wrote untrue next to a comment in a letter from the Force consultant psychiatrist to the chief medical officer that Stephen Scott was taken out of his role entirely as a result of an adverse AQR with no reference to criminality?
I can't help you with the detail. I mean, what you've just said seems logical, but I can't answer something that I just cannot remember, and I wish I could. But it's obvious from these minutes and the documents that I read and have reread that I was closely involved in the Scott case. And,
yes.
and as I say, the decisions taken at the time, although this is hypothetical now, I don't think I would have made any difference.
Grateful. Were issues of potential or possible criminality to be dealt with as a separate matter to disciplinary or welfare issues at this time in general?
They would be part of the whole in respect of deciding how to deal with the Scott case, I assume. They wouldn't be compartmentalised because they could involve both disciplinary. If they involve both criminal and disciplinary matters, they would be part of the totality of the decision-making process.
Was there at this time generally a prioritisation of secrecy, the secrecy of the SDS and its operational security that you've referred to already in your evidence, over potential disciplinary or criminal investigation of a UCO's criminality or misconduct?
Well, Ms. Simcott, as I mentioned in an earlier answer, there was an overriding concern that the secrecy of the SDS and the classification of the work of the SDS should be kept to an absolute close need to know. And yes, it would have been a consideration in making judgments on whether or not a discipline or a criminal case would follow a particular incident. But again, I can't I can't explain the detail of what decisions were made in respect of discipline or criminal. But as I say, looking at the paperwork and reading the minutes, I think I made the right judgment.
Was there a concern in the Metropolitan Police Special Branch that if the underlying details of the Scott affair became public, that there was a risk that the SDS could have been closed down?
Well, it just wasn't Scott. Any detail in respect of the work of the SDS, and I can't emphasise highly enough, it was a top secret unit operating in a statutory vacuum at the behest of the government Home Office. And as far as the branch were concerned, any handling of SDS information, intelligence, etc., had to be at the highest and most discreet level because of the embarrassment it could have been caused to the Home Office and to government if the work and understanding of the SDS had been made public at that time.
Was secrecy and the secrecy of operations and the operational security of operations of the SDS a decisive factor or a significant factor in...
I don't say it was a deciding factor, but it would be a significant factor in any consideration on what action to take in respect of an individual or a set of circumstances, because it affected both the judgment of the Chief Superintendent of S Squad and ultimately my judgment when it comes to dealing with matters that were referred to me would have taken into account the need for the utmost security of this operation, and I can't emphasise that enough.
Was there any...
And that wasn't our doing, that was the government and the Home Office wish.
Yes. Was there any concern at the time that a culture developed within the SDS and indeed potentially wider in special branch of covering up criminality or
No.
bad behaviour by UCOs?
No.
But isn't that the necessary consequence of the level of secrecy to which you've referred?
Well, it's a product of having to take into account a range of circumstances, one of which, maybe not the overriding and final judgment, is the secrecy of the operation. But I don't think in any sense was I aware that there was a culture of secrecy to avoid doing things or admitting things. It was this culture of secrecy about the very existence of the work of the SDS.
And if criminality or misconduct on behalf of UCOs became public, that secrecy would be in jeopardy, and therefore the unit itself, its existence could be in jeopardy.
Obviously, and that was part of the decision-making process that I and others had to make when it came to the delicate area of UCOs committing criminal offences. And we had to take into account not just the circumstances of the case, the overriding need of the interests of justice, but also the overriding need of government and the Home Office that whatever action we took should not jeopardise the publicity of SDS activities. And I can't emphasise that enough.
Yes, thank you. Just returning then to Scott, having approved his removal from the SDS at that early stage, you acknowledge in this document, pages 1 and 2, we must of course pay more attention to his post-SDS counselling and any supervision/welfare matters that may arise. You also approved his transfer to B Squad. Do you accept that from the document?
I accept it from the documents, but I cannot recall that process.
No. You write a minute to Daxo Peter Phelan on the 16th of May 1988, where you write, it's at page 4, minute 5, nevertheless, we do have a potential welfare problem, and I will closely monitor that and his rehabilitation to normal duties. And you continued, however, in my interview with him, he did disclose that he was totally shattered by these events and would be gone from the force by Christmas. From my own judgment of his present demeanour, I have also recommended to PT17 that he be removed from the list of authorised firearms officers. Was that a precautionary course of action in that you didn't want him able to use a firearm when there was a concern about his mental health?
Well, obviously, we were taking into account the risk the individual posed to himself and to the organisation in respect of the activities or alleged activities that were under consideration at the time. Yes. And as I say, reading that minute, I saw Scott in my office. I can't remember it. I don't remember at all. And that troubles me because I ought to remember a meeting I had, and I ought to remember the direct and detailed process, decision-making process that I was involved in, which I stand by on the minutes, but I'm troubled I can't remember it.
Yes, we understand, Mr. Gunn, and we're very grateful for your efforts. Just so that you're reassured, there's no criticism in relation to a lack of memory. If you don't remember, you don't remember. I'm just trying to establish the sort of course of events from the documents and ask you a few supplementary questions to see if you can assist further. In a further minute to Commander of PT4 and to Daxo Security from you dated the same date, the 16th of May, you made them aware of your concerns, saying, during my interview with Detective Constable Scott, I was concerned that he might be suffering from depression resultant from his AQR. And you gave them various assurances regarding his welfare, stating you would closely monitor that and his rehabilitation to normal duties, and that you counselled him on both professional and domestic issues and offered both medical and welfare assistance he rejected both offers, but I will consider to monitor these matters. Do you have any sense of now of how you were going to monitor those welfare issues in relation to him?
I stand by the judgment that it would be prudent to let Scott go on an ill health pension, and the circumstances led me to that conclusion rather than follow a disciplinary case. As far as the welfare issues are concerned, I think we need to remember we're talking about 30, 40 years ago, where welfare considerations, both in the police generally and indeed in Special Branch, were not as sophisticated as they are today. We didn't know in those days the potential psychological damage that this work was doing to these officers. Maybe we should have done, but we didn't. And the medics will tell you, and I can tell you personally, having had my own medical blip earlier this year and the benefit of counselling in respect of that, how much or how little was known in the 70s and 80s about those matters, and would we have dealt with it differently? I suggest we wouldn't have dealt with it differently, but we would have been forewarned about it, that we weren't at the time.
Thank you. On the 12th of June 1988, Mr. Scott went absent without leave, as you've referred to. He went missing. On being informed that he'd been located, you directed officers to escort him to the Metropolitan Police nursing home, and you spoke with the doctors requesting that he remain in the medical centre pending a full examination by a doctor and Dr. Farewell, the force psychiatrist. And you informed them of your concerns that he may be suffering from depression. We get that from the documents. You then updated DAXOS Phelan, writing, because of the very real possibility of compromising his position in his covert role and possibly other S-Squad activities, I did not feel it prudent, indeed practical, to launch into a discipline investigation at that time. And you say, as you are aware, it is my firm view that DC Scott's case should be pursued on a welfare medical basis, unless and until we have good reason to institute discipline inquiries. As such, we must now await the outcome of medical/psychiatric examination of him before taking any further action. And sir, for your note, it's page 7, minute 8, paragraph 3 of this same document. What was the thinking then behind dealing with Stephen Scott on a welfare medical basis rather than investigating potential disciplinary offences?
Well, I think, as I've already explained in some detail, there was an overriding need to protect the security, sensitivity and classification of the Special Demonstration Squad's activities. It would have been a feature, and a very strong feature, in my decision, as indeed was shown by the minutes. And by you asking further questions on Scott is troubling me even more, because I ought to remember, Scott was in my office allegedly. I was instrumental in the man being pensioned out on an ill health rather than a discipline. They are crucial decisions that I would have had to have made and did make for the reasons I mentioned earlier, that I felt it was best for Scott and it was best for the Metropolitan Police, and I have to say it was best for the Home Office and Government, that he should be allowed to retire in a dignified and quiet way rather than the paraphernalia of a discipline case which would have attracted huge publicity.
And was the publicity the overriding factor? I mean, is a disciplinary investigation mutually exclusive from medical ill health retirement?
I don't say it was overriding, Miss Simcott. What I do say is it was powerful.
I see. And are the two processes mutually exclusive, disciplinary investigation and medical ill health retirement, or could both have been explored?
Sorry, I didn't quite... I'm having trouble with my hearing aids, I'm afraid. I'm missing some of what you're saying.
I'll try and speak up. I was asking whether the two approaches, disciplinary investigation and medical ill health retirement, are mutually exclusive. Couldn't you consider doing both?
Well, it could, but if that was the case, it wouldn't have solved the problem of the publicity that I was trying to avoid.
Yes, Understood.
So, yes, as a consideration of the whole of the circumstances, both discipline and disciplinary issues, and I think you see from the minutes, it was detailed right up to DAC level and beyond in respect of the activity. And it was agreed that it was best for all concerned for Scott to go on an ill health. And I say, I'm taking that from the judgment of the minute, which I wouldn't have changed.
Thank you. You met with the consulting physician, we understand from the document.
So I understand.
Would that have been usual in such circumstances?
I'm not sure whether it would have been usual, but it would have been a consideration that was important, because if Scott was alleging psychological damage, then I was in no position to judge his psychology, as I've mentioned earlier. Having had some depression myself, I now know the effects that it can have. And I might have been in a better position to judge it. But in those days, we didn't. But we were concerned about the welfare of officers. It just wasn't so sophisticated in terms of its response as it is today.
Yeah. What was the purpose, though, of you as Commander Operations meeting a consultant physician in circumstances such as these?
Well, the purpose was to understand and get medical specialists' advice as to whether what Scott was alleging that, and indeed we'd had identified he was having some psychological problems, was so. It was part of the decision-making process. If you have got medical evidence that overrides some disciplinary action, maybe, particularly minor disciplinary action, if you have overriding medical evidence adding to the issues that I referred earlier about secrecy, then it would possibly tip the scale. But again, I don't recall seeing the medical officer. And I'm not sure whether I was supposed to have met the psychiatrist as well. I think I was from the minutes. And I think justifying the fact that this was my minute, I think I've even annotated something in the paragraph. So I don't deny any of the action that was taken. I just can't remember it.
Would there have been a possibility of persuasion or pressure brought to bear by the Metropolitan Police Special Branch of the doctors to go down that medical welfare route, that medical ill health retirement?
Well, it's hypothetical because I can't remember it, but under no circumstances would I have put pressure on the medical experts in respect of their advice as to the true medical condition of the officer. That would be wholly improper. And why would we call upon them if it wasn't a genuine desire to find out the specialist's advice?
Thank you. You referred in a later report to DAXOS Phelan. It's at page 8, minute 9 of the same document at tab 53, to the previous SDS case earlier this year, where the officer was granted a medical retirement with a 30% injury award following diagnosis that he was suffering a personality disorder arising from an alter ego problem. That is a closed officer, HN 155. It happened earlier. You dealt with that case earlier in the year, in February 1988. Do you have any recollection of that particular case?
I understand the comment in the minute, and that seems perfectly reasonable, but I don't recall it.
Okay, and without... Well, if you let me continue. Yeah, if you let me continue. HN 155, as I've said, is a closed officer. So please don't say his name, but do you now, sitting here today, know who I'm talking about?
Sorry?
Do you know who HN 155 is?
No.
Could we provide him with the... Without revealing his name, can you take a look at who HN 155 is?
Sorry, did you say HN 115?
No, 155.
Oh, yes, yes.
Do you recollect?
Yes, I do, yes.
You know who it is?
Yes.
Does that help refresh your memory as to your involvement in that officer's disciplinary case or not?
Its relevance to the Scut case, I can't say, but I mean, I do recall that particular officer and the circumstances of an ill health case that he was involved in, but I can't remember the detail.
Yes, thank you. Going back to MPS 0740892 at page 8, minute 9, you reported that you had stressed that we were concerned lest alter ego should become an easy excuse for any SDS officer to put forward whenever he experienced a professional or domestic problem, adding that such grounds should not become an easy option. What the inquiry understands here is meant by alter ego is his role as an undercover officer. Is that your understanding?
Yes, and it's obviously an issue. Bearing in mind again, we're talking 30, 40 years ago, we didn't understand entirely the effects, psychologically or otherwise, that this operation had on not just the officers, but the so-called victims. And I understand that. The medical requirements at that stage in terms of welfare were not sophisticated, as I said. But we would come to a conclusion based upon the information that was available to us as to whether it was an appropriate decision. And I think in that particular officer's case, we did come to the conclusion that a medical retirement was right. But we also had to take into account the wider picture that there was the possibility of people ducking out from a responsibility, either medical or discipline, by claiming damage medically from their operation.
Yes.
And I understand that, but we didn't then.
Is that what you think you meant by easy excuse and easy option? That was the concern at the time.
I might have used the phrase easy option slightly facetiously, I suspect. But it would have been an easier option for the officer. But I don't for 1 minute allege that against that particular officer.
Thank you. Here there's reference to a domestic problem being a reason why this alter ego defence might apply. Can you help us with what sort of domestic problem might a defence of alter ego apply?
Well, these officers that were undercover were operating under extreme stress. We never really understood at that stage, and we should have done, I suppose, but we didn't. The extreme stress that these officers were under. And it wasn't just them. They were living a lie. They were living a different world to their home life with their family, and we didn't fully understand that, I'm quite sure. That's a matter of regret, but it's a fact of life 30, 40 years ago, I'm afraid.
Is there a possibility that that reference was an allusion to undercover officers having deceitful sexual relationships in their cover identity?
I'm sorry, I didn't get that.
Is the reference there to a domestic problem alluding to the risk of undercover police officers having deceitful sexual relationships?
Well, obviously. There's obviously a risk that any extramarital sexual relationships of the undercover officers would affect their marriage. And taking into account the interests of the family was part of the process, but it probably obviously didn't work because it wasn't good.
But that reference there to an alter ego defence being an easy excuse for an SDS officer to put forward when he experienced a domestic problem, is that an acknowledgement of the risk of UCOs having deceitful sexual relationships in their undercover
I
identity?
don't think it's an acknowledgement. I think it's an accepted risk.
Thank you. Going back to the chronology then, on the same day, you informed Daxo S. Phelan that you had spoken with the consultant psychiatrist and in relation to Mr. Scott, and had emphasised our side of the case, and that's at page 8 of the same document, minute 10, sir. What did you mean by emphasising our side of the case to the consultant psychiatrist?
Well, I would imagine, I can't call it precisely at this stage, but I would imagine it was about the sensitivity of the work that the officer was doing. I mean, quite clearly, the fourth medical officer needed to be aware of some of the detail, if not all the detail. I'm not sure whether the psychiatrist, who was a stranger, bought into it. I don't think he was a fourth psychiatrist. We didn't have such a thing in those days. I don't think he would probably have been aware, but the sensitivities of explaining the background to the work the officers were doing, which I say again was unique. We hadn't done this before. We were on the rim and the outside of the law on many occasions, and these issues had to be based upon judgment taken in good faith at the time. And 40, 30 years later, trying to rewrite history and or reassess the circumstances that we were under then, I think is not particularly fair.
Yes, thank you. You recorded in your minute, I reiterated to the doctor our concern in this case, both about the sensitivity of the issue, which you've repeatedly referred to, and the need to protect our continuing operations. I also mentioned our concern about the alter ego problem. Dr. Farewell, in response, expressed concern about DC Scott's apparent mental and medical condition, and advised that he should not be seen by any police officer until so advised. That's page 9, minute 10, sir. Despite that, you obtained Daxo S. Phelan's approval to visit Scott to retrieve some confidential documents. The inquiry understands that the concern about the documents he held was that they related to his covert role, and that their return was necessary to prevent compromise of DC Scott's role, SDS operations generally, and to protect the safety of colleagues still engaged on operations. Is that right?
I think that's entirely sensible.
You recorded that Dr. Farewell had agreed to HN 337 visiting Mr. Scott for the particular purpose of retrieving the documents, and that he would call Mr. Scott first. We see that from the documents. Following the successful retrieval of the documents, you issued instructions that there be no contact with Mr. Scott, and any unexpected contact to be reported to you immediately. That's page 10 and minute 11 of the same document. Presumably, the reason for that instruction was that once the documents had been retrieved, you were concerned, as Dr. Farewell was, about his mental health and his welfare.
Well, yes, that goes back to the point I made earlier. I'm not sure that Dr. Farewell was aware of the nature, and indeed Dr. Bott would not have been aware of the specific details of the operation, but he would be aware of the high classification, the top secret sensitivity of the operation, and that was a matter for Dr. Bott to take into account when he did his medical thing.
Thank you. As a result of a report received, I don't think we need to bring it up on screen, but it's MPS 0740937. It's at tab 60 of your bundle, sir. You visited North Yorkshire Police to establish what records they held on Mr. Scott. We see that from the documents and pages 10 and 11, minute 12 of 0740892. The concern about the North Yorkshire Police's records was that Mr. Scott may have revealed to, or indeed did reveal to them, details about his SDS duties. Is that right?
For me, the travel to North Yorkshire is one of the most troubling parts of this. If I saw, and I can't remember, but I must have seen somebody at ACPO level, a chief constable or assistant chief constable, I must have been driven all the way to North Yorkshire and back. For me, not now to be able to remember any of that mystifies me and troubles me. But whatever happened, it would have been for the specific purpose of maintaining the security of the SDS in respect of the reputation of the Metropolitan Police and the need to know. And if we had information around SCUT activities in North Yorkshire or elsewhere, then we would need to verify and or try and minimise the damage that could potentially have been caused on that. But as I say...
You don't remember it?
I can't remember.
You would have wanted the records they held to be destroyed, and I think we see from the paperwork that they agreed to do that. Does that sound like the purpose, one of the purposes of attending?
Well, I don't recall, but I don't see why I would have wanted the paperwork destroyed. It doesn't seem to follow. It was a matter of record. We weren't trying to hide anything. But again, if I said that, I can't recall why.
And you wanted their assurance that they wouldn't disseminate anything they'd been told further, presumably?
Well, obviously.
You later addressed the course of action to be taken against Mr. Scott, writing, "It is unfortunate that Scott not only broke his cover, but also reprehensibly gave details of the nature of his SDS work to unauthorised persons. I fear that little will be achieved in pursuing any disciplinary action against Scott. Indeed, we have more to lose. Suitable damage limitation has been taken in respect of North Yorkshire Police Force, and I feel this particular facet of the Scott saga must rest there." And that's page 11, minute 12 of the same document, sir. Why did you consider there was little to be achieved by pursuing disciplinary action?
I stand by the judgment I made in respect of the sensitivity and security needs of the work that Scott was involved in and the potential for that matter becoming public with the huge danger and difficulty it would created both politically and police-wise for us and government.
And is that what you think you meant by "we have more to lose"?
Possibly, yeah.
And the "we" in that sentence, is that the police, the government, or both?
Both.
Was part of what was to be lost a good reputation of the Metropolitan Police Special Branch?
I'm sorry, say again?
Was part of what could potentially be lost by pursuing disciplinary action against Mr. Scott the good reputation of Metropolitan Police Special Branch in the eyes of the public?
Well, it would have been an issue, yes. And it was taken... I mean, again, I'm struggling to recall, which I can't, the detail, and by looking at these documents, I can only judge what I did then and comment upon what I feel was the reason for making that judgment. There was also, looking at these minutes, and I don't know whether I'm able to say this, but there was also quite a strong involvement of the security service in this issue.
Yes, I'll come to that a little later, if I may, and I'll ask you some questions on that in a moment.
Thank you.
Just finishing off this document, as you've repeatedly referred to, part of what could be lost, as referred to in this document, is the secrecy of the SDS.
Yes.
If it became public that an SDS UCO had gone off the rails in this way, would the continued existence of the SDS also be in jeopardy?
Of course.
You've referred to the security...
And if I may add to that...
Yes.
The efficiency and effectiveness of the SDS at the time in terms of the information it was providing, the intelligence it was providing, was crucial to the Home Office, to the government, to the security service at the time. So it wouldn't just been a question of the SDS folding. That vital intelligence that we were asked to gain, which we did, over the years would have gone. Where is the vacuum that would have filled that? And I think we're viewing some of that today with the mismatch between intelligence and public order problems.
Yes, I see. Thank you. In your statement at paragraph 79F, you say the security service was possibly more concerned about revelations by DC Scutt than even we were. Can you elaborate on that for us, please?
Well, yes, I can. In respect of a generality of security service involvement in SDS matters. I mean, I can't specifically say they're involved. I've read the minutes about their concern, their serious concern about Scutt, but I can't recall the detail. The security service knew exactly what we were doing in the SDS. They lived off the product, they enjoyed the product, they even targeted and helped targeting. So it's important that the security service were part of the equation when it came to decision-making process on all matters dealing with SDS that might affect the security service work. And it's no good saying I was upstairs collecting fares at the time. They were involved in most of the work of the SDS, particularly in the early days when we were dealing with subversion, extremism left, which was the security service province. And I think I have to say, having listened to each of the tranches, every bit of evidence that's been delivered to this inquiry so far, I don't see much from the security service in terms of supporting or justifying what we did in those days, and I think that is a matter of concern.
Thank you. Did the collective concerns that you've repeatedly referred to amongst both the MPS and the security service, the desire to keep the SDS a secret, their operations a secret, effectively prohibit disciplinary action or criminal prosecution of an undercover police officer in the SDS?
No, it didn't prohibit the action, I would suspect. And again, I'm going back to the minutes. It didn't prohibit, because it would have been a police operational decision as to whether or not a disciplinary action was started and progressed. What it did do was influence and or be part of the judgment as to which action was best to take. And I can only assume, looking at the minutes and the details that I don't recall, it was judged at that time with the full agreement of the security service that a disciplinary route would not have been a wise or prudent way of dealing with this matter in respect of the downside that would have come from the publicity that would inevitably have followed. And as I say, although I still can't remember the details of the case, I would stand by that today, given the same set of circumstances.
Was there any recognition or consideration that such influence that secrecy and security of operations had over other factors was a rather dangerous precedent to set amongst the SDS and what action to take against UCOs?
The Special Branch had many experienced and diligent officers at all levels, although you could be surprised thinking it from some of the details that have been presented in this inquiry. But the experience of the Special Branch officers, particularly the managers, in conjunction with the Home Office, in conjunction with the Security Service, there was a common agreement, and I can't emphasise this enough, there was a common agreement that the secrecy and confidentiality and knowledge of the work of the SDS should be kept to an absolute need to know. And that need to know, I don't think, has fully been explained yet to this inquiry.
Thank you. Sarah, I'm conscious of the time. Would that be a convenient moment to break?
Certainly. We'll break for 15 minutes and resume then.
Thank you very much. All rise. I'll pause a moment. Oh, there we go. Mr. Gunn, I'll continue just finishing off the chronology in relation to the Scott affair, if I may, appreciating, as you've already said, your lack of recollection. So there had been early medical advice that prohibited contact with Mr. Scott, as we dealt with just before the break. Following your approach to the Chief Medical Officer and the 4 psychiatrists, they agreed that the pressing operational need to assess potential damage limitation factors overrode the medical concern for Scott. That's so that same document 0740892 at page 12, minute 13. You've referred a number of times to the competing factors of secrecy, operational security, safety of the undercover officers, and the factors of what Mr. Scott's welfare. Is that an example of the pressing operational need overriding temporarily Mr. Scott's welfare in order to assure yourself that there was indeed damage limitation?
Well, it's part of the consideration in the round, yes.
Thank you. So you instructed officers to visit Mr. Scott to gain his confidence and ascertain whether he had made any further unauthorised disclosures. The purpose of the visit was recorded as being to establish his current demeanour and whether or not he may have disclosed similar details to any other unauthorised source. When the visit was refused, Daxo S. Phelan ordered an unannounced approach. That's is at page 13 of that document at minute 15. There's no need to put it on screen. Prior to that planned visit, you'd received a copy of a letter from the consultant psychiatrist to Dr. Bott, the Chief Medical Officer. And that letter raised serious concerns about Stephen Scott's mental state and advised against police contact. What do you consider your reaction was likely to have been to that letter at that time?
Between a rock and a hard place, I would think. I had to make a judgment. I'm saying I had to make a judgment. I did make a judgment. I just can't recall it.
Yes.
But I would have taken into account the sensitivity issues, the medical issues, including the psychiatric issues, and weighing it all up, I would have to have made a decision. Sometimes you have to make decisions that don't always turn out correct, and certainly 30 or 40 years later may look a little bit thin. But at the time that I made that decision, according to the minute, and I say again, I wouldn't have changed it.
So you briefed the officers to proceed with the visit. That visit went ahead. You also disagreed with several of Mr. Scott's claims in the letter, particularly an allegation that his commander had hinted at an affair. Do you take that to be a reference to you?
Well, I suppose it must be, but I don't recall it.
No. You said you had arranged to see Dr. Bott and Dr. Farewell to set the record straight. Was that essentially to persuade them that some of what Mr. Scott was telling them was untrue so far as you and Special Branch were concerned?
No, Miss Simcoe, as I said before, there was no element of persuasion in respect of the medical opinion. The medics, Dr. Bott and the psychiatrist, are experts in what they do. They would not welcome intrusion and or emphasis on their decision. It's their decision alone. I say again, it's part of the whole jigsaw that I would consider in terms of coming to the final judgment as to what was best for Mr. Scott. And actually, looking at the minutes there, you could say in the end, it was equal about concern for Mr. Scott and the reputation of the Metropolitan Police. Both would have suffered, or could have suffered, if a different course of action had been taken.
By this stage, do you think you had resolved, at least in your own opinion, that the right course of action was indeed to medically retire Mr. Scott on the grounds of ill health?
Well, I must have done, yes, because that's what happened.
You forwarded the letter to Daxo Phelan and confirmed that officers had been briefed to attempt contact with Scott, and you noted and recorded that Dr. Bott was happy with our actions to date. That was in the context of those particular circumstances, wasn't it?
Yes.
Setting the record
Well, I
straight
assume
and
so. I assume so. Yeah.
balancing those competing factors. Following that visit, you wrote in a minute to Daxo S. Phelan, I'm now confident that adequate damage limitation measures have been taken to protect SDS activities, and I'm hopeful that that aspect of the Scott affair has been resolved. And that's page 14, minute 17 of that same document, sir. You suggested to Daxo S. Phelan that Commander P was made aware, and he may want to update AXO, the Assistant Commissioner. At that stage, notwithstanding further advice from Dr. Bott that there should be no visits to Mr. Scott, that's page 15, minute 18, you, upon being informed of the proposed immediate medical discharge on ill health grounds, proposed that Mr. Scott be seen once more to assess his current demeanour. Why was it necessary at that stage, given that decision had been made, apparently, from the documents, to assess his current demeanour?
Well, I assume because there was ongoing concern about whether Mr. Scott was going to agree with the action that I had recommended. I don't know the detail behind that, but obviously these things are just not open and shut. These things have continuum, and the issues of Scott would have reverberated after he'd been dealt with. So it was of interest to know, if we could, how Mr. Scott might approach such matters, and that was presumably the reason for keeping in touch or making an assessment of his demeanour.
And so would you say that there was still, in your view, a pressing operational reason to see him at that stage?
Well, I don't know how many times I've got to say it, but it would have been an operational consideration that was pretty high in our consideration of the whole matter, but it wouldn't necessarily have been it wasn't necessarily the single and sole reason.
And that's even in circumstances where you state in the minute 19 at page 16, that you were confident his medical retirement would bring matters to a close.
Well, I was at the time, I assume, otherwise I wouldn't have written it.
In relation to liaison with the security services over this, we touched upon it before the break. There's a security service meeting with the SDS where they've noted between DCI Martin Gray and HN 109, a closed officer. That's at UCPI 30663 at page 3, and that's tab 72 of your bundle, sir. And it reads, Home Office, the SDS consider this to be an internal matter only. They may decide to allude to it in their 1988 annual report to the Home Office, but were very exercised at the idea of the problem being brought to the immediate attention of the Home Office. DCI Malcolm MacLeod of C Squad strongly supports them in this line, and F4 redacted in conversation assured them that we had no intention of saying anything to the Home Office. In the interests of good F4 SDS relations, they should not be pushed on the point as they are extremely sensitive about it. They will obviously reconsider if the case starts to explode on them. You were asked about that in your witness statement, and at 79F, referring to that meeting, you say it's clear the security service was possibly more concerned about revelations by DC Scott than even we were. Its officer's comment also fails to understand the nature of the relationship between the MPS and the Home Office, which was properly constrained to policy and funding, both generally and specifically in terms of the SDS. DC Scott's removal from the SDS and the subsequent welfare concerns were operational and administrative matters that were wholly and solely the concern of the MPS. But wasn't the real concern about informing the Home Office that the Home Office was extremely concerned, as you've said a number of times, to keep SDS operations secret and their funding of them a secret from the public, and that this may have revealed those facts?
Well, that may well be a consideration, as I've said before. It emphasises the sensitivity in the Home Office circles not just Home Office circles, the security service as well, about the whole need for secrecy on these operations. I'm not aware, other than from the minute, that the security service were clearly as much, if not more, concerned than we were, according to the minute. And as I say, I don't recall it, but I stand by it if it's written down there. And I think it underlines again what I tried to say earlier, that the security service were head and shoulders and above dealing with these matters in respect of keeping the secrecy of this operation sacrosanct. And we, in addition to the security service, would take into account the position of the Home Office and government in making those judgments. And that, I believe, is a clear implication of those minutes.
There was a risk, as we've discussed earlier this morning, that if the full details of the Scut affair became known to the Home Office, there was a risk that they may have decided that the SDS couldn't continue as a unit. Is that right?
No, that's your judgment, and I don't agree with it. It would have been an issue, and as I've said, the Home Office was very sensitive about the activities of the SDS and how we controlled the need to know. But I don't think it automatically assumes that your version is that it would have changed the SDS approval by the Home Office. They funded, or part funded the SDS for 25 years. They knew that these were very sensitive, difficult operational matters. So the line between operations and policy in respect of the police, the security service and the Home Office was a thin one, but it was very important. And we had to take into account sensitivities of each of those players, if I can put it that way, in respect of any action that was taken by the SDS.
The Scut affair, as it appears from the documents, was clearly significant at the time. Don't you consider that the Home Office should have been told about the development of what was happening with Mr. Scut?
Well, hindsight's a valuable thing. Maybe you could. My judgment at the time was not. And that was an operational decision for the police. I don't think you should run away with the idea that the Home Office were automatically excluded from every piece of information on the SDS. They weren't. There were some operational matters that may have been alluded to. They would have to have been alluded to in respect of the part funding the Home Office gave. But I don't think that adds up to the fact that the Home Office would have changed their mind just because there was another bucket coming their way in respect of Scut.
Where you knew in Special Branch at the time that the secrecy of SDS operations and its operational security was of primary concern to the Home Office, didn't something such as the Scut affair, which threatened that, need to be notified to them?
Yes, I can take that alternative view, and I don't say that I was absolutely right. I had to make a judgment. I was between a rock and a hard place, and I made that judgment, and as the minutes show, I explained it.
Would you make a different judgment now with the benefit of hindsight in relation to telling the Home Office?
I think that's entirely hypothetical. All I can say is, given the same set of circumstances, I wouldn't have changed the decision I made at the time, although I don't recall it.
Thank you. During the Scut affair, you instructed DCI Eric Docker to conduct a review of the SDS, focusing upon viability, recruitment, deployment strategy, and post-field supervision. I take it from all you've said this morning, you have no particular recollection of that, or do you?
Well, that's exactly my point in terms of memory. I should have remembered that. I mean, that was a perfectly proper and legitimate response that I did to Mr. Docker in respect of reviewing the work of the SDS in respect of the Scut affair. It was time we reviewed its viability, the need for it, how we trained our officers, how the welfare aspects were dealt with. And I think all my minute there, and as I say, I don't recall making it, but I wouldn't have made it any different today, covered those areas of proper supervision of the SDS by the management of Special Branch.
Yes.
And I don't think any other interpretation is viable.
Yes, thank you. And sir, for your note, it's MPS 0731676 at page 1, minute 1A, tab 61 of your bundle for the request for the review. The recommendations of that review by DCI DOCA are at MPS 0726998 at page 7, and that's tab 39 of your bundle, sir. I just want to go to some of those recommendations and ask you about them, Mr. Gunn. You have addressed those recommendations in some detail, and you have said that you supported DCI DOCA's recommendations. One of them concerned the background of a UCO, and it said this: whenever possible, only married officers with a stable family background should be selected for SDS duties, although there should not be a total bar on the recruitment of single officers who may be deemed especially suitable. And you emphasised that only in wholly exceptional cases should single officers be considered, and then only after prior discussion with the candidate's squad chief superintendent and commander ops. I take it you don't have a particular recollection of that recommendation now?
I don't have a recollection, but it's one that I would have made again, given the circumstances.
Yes, and I'm going to come to that particular recommendation a little later, if I may, but just dealing with the others. You also approved the recommendation of the convening of a case conference chaired by Commander Operations P and Chief Superintendent C, at which the SDS candidate selections would be confirmed, having regard to an oral presentation by the SDS DCI. You also approved the recommendation for psychiatric testing of SDS candidates at the recruitment stage and of former UCOs as part of the post-SDS supervision procedure. Is that right?
Yes, doesn't that strike you as a sensible reaction to an affair that Scott had created for the SDS? And I was trying to oversee the reaction and correction of anything, lessons we needed to know at the time. And that seemed to me, in terms of looking through those minutes, recommendations, that they seemed to be valid.
Thank you. You noted at page 5 of MPS 0726998, minute 4, it's tab 39 again, sir, that the real problem, as you say, lay in the necessarily long reins of supervision given to field officers, and that some tightening was desirable. What was the concern about the necessarily long reins of supervision, so far as
well, I think just as the minute says, the essence of the undercover work that these officers were doing was entirely different, as I tried to explain earlier, to the normal undercover work, which was short-lived, focused, specifically requiring getting evidence to prefer charges. The SDS operation was entirely different. Well, not entirely different. It was built upon the same, and this is a point that's not necessarily been, I think, understood by the inquiry. Undercover policing is all about deception, deceit, intrigue. I'm sorry, but that's the reality of what undercover policing is. When you have officers dealing with that, there is a sensitivity that they should understand the problems that they're going to face, which we tried in terms of management. But the SDS officers who were undercover were out on their own, in the field, sometimes in dangerous circumstances, and their command was back to the office. I thought at the time, was there some way we could put a management level or a supervision level to shorten the lines of communication between the the undercover officers out there on their own in dangerous circumstances and the back office in respect of supervision. And as I say, I again don't remember making this minute, but I'm rather saddened that I can't remember it, because I think I would have said that's exactly the response I would have expected from supervisors of the STS.
And in terms of what you meant by tightening up supervision, in practice, is that what you've just alluded to, a closer link between
Yes.
the back office and the
Yes,
UCO?
and for not just the welfare of the officer, but also for overseeing some of the behaviours. I mean, these officers were out on their own, and sadly, some transgressed. It's a matter of huge regret, but it happened. If there had been a closer supervision from the office to the field, it is possible we could have obviated the need for the distress that caused.
Was there a need to also have closer vision from senior officers at your level and just below, or was you just talking about the SDS itself?
No, it goes up the chain, but what I've said earlier, you can't, well, I don't know, maybe you can. One shouldn't expect the head of the organisation, the Commander Ops, when for the very reasons I explained earlier, the plethora of activity, responsibility and work that he had to deal with, you can't expect him to know every minutiae and detail of the operational activities of SDS officers. We relied on the near supervisors, the back office, the chief inspector and the superintendent and chief superintendent to provide that information to me. Sadly, it didn't happen on a couple of occasions, and that's a matter of regret. But the idea in that minute of closer supervision was to shorten the line of command between those in a difficult position and those in the office.
Thank you. In your inquiry witness statement at paragraph 33, you acknowledge that the intended level of senior oversight never materialised, and you attributed that to not a disregard, but to a looser attitude towards supervision at that time. Looser attitude to supervision by who?
Well, by the chain of command in SDS, I assume.
And higher up as well in special branch?
And higher up, yes.
And what did you mean by looser attitude?
By what?
By looser attitude.
Well, I can't recall precisely what I meant by it at that stage, but it would presumably have been, didn't take into consideration quite as seriously as it should have done.
Because wasn't one important reason for the review and the recommendations to address a lack of or an inadequate level of supervision of UCOs?
Yes.
So you were expecting those recommendations to be carried forward?
Yes.
DCI Docker concluded in his review that officers of the Special Demonstration Squad are in a prime position to be able to report on any threat from London's principal subversive groups, and it is therefore essential that the SDS be allowed to continue its role as hitherto. You accepted that conclusion at the time, so presumably you agreed with it.
I did.
And you certainly didn't give any further instruction to explore the closing down of the SDS at that stage, so far as we know.
Certainly not. There were no circumstances that I thought would justify closing it down, and it wouldn't have just been a decision of Special Branch to close it down. It would have involved
The Home Office.
Right up to the Commissioner, it would have involved the Home Office, and it would have involved the Security Service.
Yes, thank you. In 1988, there was a briefing from the Security Service outlining a reduction in the threat from subversion. Do you recall that now?
Is this a Harris definition? You were
So-
following the Harris definition?
Yes, and
Yes, I do recall the change of definition of subversion, and I think the Security Service took the view that if subversion in its new definition was the case, then they would back out or not be so interested, in my words, in public order issues. I think Special Branch Command, of which I was part, took a slightly wider view, or more pragmatic view, can I say, of public order. And we did not accept, at least I didn't accept, that certain elements of the activity that caused public order wasn't described as subversion. And I believe that has been justified since in a recommendation that Hall, the government security advisor, is suggesting there should be a law against subversion, so it's still current today. And it's still a matter that was burning into our souls at the time, that we were taking on, without necessarily the support or encouragement of the security service, on public order matters, and that created a schism between the two.
I see, thank you. I'd like to leave the Scott affair now and move to some different topics.
Thank you.
The first one is Debenhams and the prosecution against Clark and Shepherd in relation to the incendiary devices planted at Debenhams. You deal with this at paragraph 148 of your statement. You were asked questions in your Rule 9 by the inquiry about that. It's page 58, sir, of Mr. Gunn's statement. And you say that Metropolitan Police Special Branch had no involvement in the prosecution regarding Debenhams of Clark and Shepherd, to your recollection. Is that right?
I believe that to be so. It was the operational responsibility of the anti-terrorist branch.
And you personally, as Commander Operations, didn't play any role that you can recall in the prosecution itself?
Correct.
Or in any disclosure decisions at the time in relation to the trial, is that
Correct.
right? Should there have been greater involvement by you or personally as Commander Ops or Special Branch generally, given the known involvement of Bob Lambert in the run-up to that and in the prosecution itself?
In respect of the circumstances surrounding that issue, yes, hindsight would say there should have been closer involvement. I can't say on the morning meetings that we had, which included Commander Churchill Coleman of the anti-terrorist squad, I can't say he didn't actually refer to it. I can't remember, but it would seem logical that he would refer to it as a strategic issue, but not as an operational issue. But obviously, with the benefit of hindsight and what's been discovered since, a closer SB, not involvement in the prosecution because there's a separation line there, but a closer involvement in the events or knowledge of the events would probably have been prudent.
Thank you. Moving on then, I want to ask you about the use of deceased children's identities by undercover police officers. In your inquiry witness statement, you describe the use of deceased children's identities as a well-established practice when you became Commander Operations. That's paragraph 84 of your statement, is that right?
Yes.
What was your understanding at the time of the legal basis for using such a practice?
This whole subject troubles me greatly, but it's worth bearing in mind and pointing out to the inquiry. We didn't invent this tactic. It was used as early as the first part of the 1900s by the military, I understand. It was used by Czech spies in respect of spying charges that were proffered here later. It found popular in Forsyth's novel. And when Special Branch used or took up the thing, it was before my time, but a judgment would have been made on the sensitivities of that action. Clearly, it is difficult to justify morally. It is very difficult to justify the fact that if, and this is where I want to emphasise, if the information had got out, it would have caused much distress to the families, as indeed it has, and that's a matter of personal regret, because some of the content of the hearings we've had from those that experienced it were heartrending, and that's a great burden. However, in respect of the use and continued use of it, first of all, it was necessary because we needed secure legends for our undercover officers. I believe 2 or 3 had been compromised from purely fictitious legends, and that at the time a judgment was taken that that was, for the interest and safety of the officer, that was the right decision. Again, that is a matter of judgment. Again, at the time, you've got to bear in mind this was 40 years ago. There were no computerized issues that we can do now. We were operating in a sterile atmosphere as far as false documentation goes. So the judgment taken, I'm pretty sure, and my judgment when I took over as Commander Ops, is as damaging as this might be, and indeed it has been extremely damaging, then it was necessary operationally to adopt that process.
And was that...
And if I could just say, we did not believe, with the top secret, the secret nature of the work and the tactic, we did not believe that would ever get into the public domain. It didn't get into the public domain from the SDS or the police. And I'll leave that judgment as to how it got into the public domain for others to make. But it was that caused the stress, hurt and unhappiness of the poor families, not our particular specific use of the tactic, although obviously the use exacerbated the problem. But it was a very difficult and a very stressful time for officers and commander and senior officers, and with the benefit of hindsight, we'd never use it again. We wouldn't need to use it again, and I personally apologise to the families that were involved in that, because there were some heartrending cases.
Thank you. But can we just look at, on becoming Commander Operations and your knowledge of the use of this tactic, what did you understand to be, because you've referred to undercover operations, undercover officers having to act within the law, what did you understand to be the legal basis or the lawful authority for the use of this particular tactic?
Well, there was no legal basis for it, as I understood. And indeed, there was no legal basis for a lot of the work we were doing. If you remember, and I say again, 1968 and 40 years on, we had no statutory backing for what we were doing until REPA, Regulation of Investigatory Powers Act in 2000. We had no authority, legal authority, to have covert human intelligence sources until that act. We were operating in a statutory vacuum. We had very little statutory backing for what we did. It was fly by the seat of your pants and make judgments on difficult political, operational decisions in everything we did. And I think in 40 years of the activity, I think we did that. We achieved, and this is another thing that I don't think this inquiry has fully covered, the importance of the work and the results that were achieved by our brave officers who didn't go off-piste, who didn't engage in sexual relations, and that's regrettable and should never have happened. Where did we hear, where have we heard about all the excellent undercover operational work that took place for 40 years? Where have we heard that in this inquiry? I accept entirely that much of it is secret and will probably be held in camera, but that will never reach the public domain. What the public have heard and will hear is the mistakes, the cock-ups, the faults, the damages of the people that did wrong. And that's wrong. And I take full responsibility as Commander Ops for whatever happened on my watch.
you accept in your inquiry witness statement, as I've said, that you were aware of this practice at the time. That is contrary to the officer's note of your discussion with the Operation Hearn investigator of your interview on the 8th of April 2013. And it's also contrary to what you said in your signed Operation Hearn witness statement signed on the 15th of May 2013, and for everyone's note, it's MPS 0723255, page 4. It's at tab 2 of your bundle, sir. What was the reason for a denial of knowledge of the use of this practice in that statement and to that investigation?
I'm glad you mentioned Operation Hearn, because it's a matter that's been troubling me and other officers involved in this inquiry quite considerably. Could I just put into context the details given in Operation Hearn to the officers that interviewed us were purely and simply explained to us as details for the background knowledge of SDS, because the people doing the inquiry under the Chief Constable in respect of Hearn had no idea of any of this history. That's what we were asked about. We were never told that that information, which we weren't allowed to consult documents, we were doing it from memory, and we made mistakes, as indeed I made a mistake, and I wanted to change the statement, as I said. The fact is, when those statements and notes, and some of them have been declared as public documents to this inquiry and have reached the public domain, were notes of interviews in Operation Hearn that were never ever signed by the officer who made them. That is wrong, and I don't believe it should have happened. And I query whether the Operational Hearn statements and information should be quoted within this inquiry many years later, with the inference that what you told Operation Hearn when you weren't allowed to do any review of documents, etc., and what you told under caution, or not under caution, but you told in your witness statement for this inquiry differed. It's not surprising. And I think I would say, drawing a conclusion for any of those officers that made different opinions to their Rule 9 statements to this inquiry against what they said in Operation Hearn should be treated with the utmost caution, because it was for a different purpose and a different reason.
But this is a statement to a police investigation, which statement you signed,
yes,
and signed with a statement of truth,
yep,
which says, "I am not aware that the identities of dead children were used in creating the false identities and do not believe that to be so." That is a fact about your knowledge of a practice, which you now say is incorrect.
That's
because
incorrect.
In your inquiry
And
witness statement,
so
can I finish? In your inquiry witness statement, you accept that you did know. How
yes,
would access to documents have affected your knowledge of whether
yes,
you knew something or didn't at the
yes,
time?
What I was trying to explain in that part of the statement was, to the best of my knowledge, as Commander Ops, I never signed off an application for a birth certificate of a dead child. And I can't recall I ever did, and I don't believe there's any documentation that says I did. So my comment about I don't believe that it happened was about I don't believe I answered any queries about it, or indeed approved any applications. The way that was put down in the first statement is incorrect, and I tried to change it in my other statement, and if that didn't come out completely as I've just explained, then I'm sorry.
So it's a product of loose language in the
Yes.
Operation Hearn statement.
Yes.
Did you find out about this practice only upon becoming Commander Operations in Special Branch, or did you know about it before?
It's difficult to say. I'm not sure. It's logical I might have known about it before, but I can't be certain. But I certainly can say it was not common knowledge within the branch.
Thank you. You accept that as Commander Operations, you could have put an end to.
Because it hadn't leaked out to the public domain and caused any problems, it seemed to be the most suitable method to provide a full and supportable legend to undercover officers. If the issue of the legality and or the propriety of it had been raised, then I would have obviously taken inquiries, but it wasn't. And in my judgment at the time, because it wasn't a burning issue. But it, obviously with hindsight, and it having been exposed by this inquiry, the tactic being exposed, it would have been better if I'd have had a closer look at those matters.
Thank you. Did you give any consideration at the time to the moral and ethical implications of the MPS using such a practice? I ask because you refer to its use by Václav Jelinek, the communist spy from Czechoslovakia, and you've relied today again on that it wasn't a practice invented by the MPS. But were you aware of that case, the Václav Jelinek case at the time?
Yes.
Did the fact that a spy in communist Czechoslovakia employed such a practice not give you pause for thought as to its moral and ethical implications?
Well, as I've tried to explain, Ms. Simcock, it was morally wrong. We shouldn't necessarily have used that tactic in terms of the distress and hurt that it's caused, and I accept that entirely. All I can say is, in terms of the torrid period we were in the 70s and 80s, and some of the 90s, the security and safety of our officers under cover was of great importance. I believe before my time, 2 or 3 officers, as I said, had been compromised, and a judgment was taken to use this tactic. Given time again, given the knowledge that it did get out, when every one of us thought it would never get out, and it shouldn't have got out, then the judgment was probably at least supportable, if not totally incontrovertible. So, yes, it shouldn't have happened.
And you say, as you've said today, paragraph 87 of your statement, that none of us imagined that the use of the tactic would ever be revealed. But your knowledge of the Václav Jelinek case, did that not give you pause for thought that it had been revealed there? Was any consideration given to the possibility of revelation of this tactic by activists or otherwise?
Sorry, I don't think there was a read across from the spy case to the use for children's families. I don't think so. I can't say, I can't remember.
Was the possibility that suspicious activists could unmask a UCO and in the process discover and reveal this tactic ever considered at the time?
Yes, there was a constant concern, obviously, and that matter was continually considered as to whether or not the tactic should remain. I don't, again, recall the day-to-day issues of that, but as an overriding principle and policy, I'm sure that was part of our consideration. And
was there a view that because of the ethical and unethical and immoral nature of this tactic, that a consideration that, well, the MPS would do everything in its power to keep it secret?
Yes.
Was any consideration given to the impact upon the family member in the Václav Jelinek case in terms of the immense distress caused by the revelation of that tactic? What consideration was given to the impact upon families?
I can't comment upon individual cases because I do not remember the detail. All I can say, as I've already said, it was a matter of great concern that the distress and hurt to the families of the use of this tactic resulted. if we could have done without it, we would. At the time, we considered it was an appropriate, proportionate and necessary means of protecting our undercover officers. We did take into account, I'm absolutely certain, and I was at the time troubled, if this ever got out, it was going to be extremely embarrassing, not just for the police, but for the Home Office and the government. But it didn't get out. Now, that's not justification, I understand, for using it, but it is a consideration in terms of context and proportionality of the risk that we faced and how we dealt with that risk. And I said, and I apologise again to the families, those heart-rending statements they've given to this inquiry, I can't excuse in terms of causing them that trouble.
I just want to ask you about a reference in the annual report of 1990 to 1991. It's dated the 4th of February 91. It's MPS 0728958. It's tab 38 of your bundles, sir. It records that the provision of cover backgrounds was becoming more difficult, with public records becoming computerised, and then there's a redaction. You received those reports as Commander Ops at the time.
Yes.
Was that an opportunity to look at the necessity for this practice and the appropriateness of it?
Yeah, what was the date of this annual report?
It was the 4th of February 1991.
91. Yes, it would have been an opportunity, but as I said earlier, there was 101 things I was dealing with at the time: Irish terrorism, international terrorism, Lockerbie, extreme left-wing, extreme right-wing, and not all of the minutiae of the details of those issues would have struck me as being something that should have acted upon. With hindsight, you're right, it should have done.
Thank you. As Commander Operations, do you know whether the Home Office was aware of the Metropolitan Police's use of this tactic at the time?
I don't personally recall on my watch the Home Office ever being involved. Whether they were initially or after it was used, I can't say.
If at the time you had been aware they were aware of the practice, would that have provided reassurance that the practice was authorised outside of the Metropolitan Police Special Branch in government?
Well, that's a matter of judgment. All I can say is it would have, the support of the Home Office on something like that would have helped clarify the judgment of the officers that took that decision. I can't say whether or not Home Office saying go ahead with it or were specifically asked about it. I don't believe they were. I find it practically, in terms of the duration of this undercover operation, from 1968 through to 2008, I can't honestly think that at some stage in the longevity of this inquiry, activity, the Home Office wouldn't have been aware of it, but I can't say.
And what about in relation to those senior Metropolitan Police officers above you? You've accepted that you were aware of its use at the time. Do you know, or do you have cause to believe whether those above you also knew?
Well, I think my answer to the previous question is exactly the same for that. I don't know. I find it difficult to believe that they didn't, particularly Assistant Commissioner Specialist Operations, because he was overall in charge of all the matters that we were dealing with STS. Whether or not the Commissioner or others higher up knew, I don't know.
Okay, thank you very much. I'd like to move on to a different topic now, please. Thank you. And you've been asked about this in your witness statement, And that's the subject of knowledge of sexual relationships, deceitful sexual relationships by undercover officers in their cover identity. You say at paragraph 120 of your witness statement that when you took over as Commander Operations, you weren't aware that any UCO had engaged in sexual activity with members of the public in their cover identity. Is that right?
That is correct.
When were you first aware of any such allegation?
That's difficult to say because the assumption that's been used in this inquiry time and time again is that we must have known about it as senior officers, or we either acquiesced to it, positively supported it, or even directed it. That is not true as far as I'm concerned. On my watch, between 88 and 91, I can honestly say I did not know that officers were engaged in sexual activity. I can say that of the 9 or 10 officers to which that is alleged in my watch, that shouldn't have happened. It was wrong, and if I'd have known, it would have been hopefully stopped. And when I say hopefully, because the circumstances of each one of those may be different and would need certain undercurrent of examination, but it was wrong. It shouldn't have happened, and I apologise again, as everyone else seems to apologise, but I do it sincerely in respect of sexual activity. But in terms of context and proportionality, again, I go back to what I said earlier. 9 or 10 people allegedly transgress in my period. What about all the dozens of other good, brave, intelligence-gathering undercover officers who didn't go off-piste, who didn't go on a journey of their own and commit sexual offences? When have we heard about those? All I'm saying, Mrs. Simcock, is there is some balance that's not been drawn upon this, and I want to put the context and balance without in any way justifying the activity, because it shouldn't have happened. And indeed, when one of my chief superintendents were alleged to have known about it, he should have told me.
Yes, we'll come to that in a moment, if I may. This paragraph of your witness statement refers to an allegation made either by or on behalf of Stefan Scutt. I'm sorry to have to return to him, as I know what you've said about your recollection there. But from the papers, it seems you were made aware of an allegation that he had made, that an undercover officer had engaged in sexual activity whilst undercover. If we can look at MPS 07408992 at page 19 and 20, please, and it's tab 53 of your bundles there. This is a minute dated the 25th of November 1988, and it shows that that allegation was investigated by DCI Martin Gray and DI HN 109, a closed officer. Those were SDS managers at the time. Is that what you would have expected to have been the initial MPS response to such an allegation, the SDS management investigating their own UCOs?
Any information that came back to the back office that officers were engaging in this sort of behaviour should have been brought to the attention of the supervisory officers at very least, and certainly the supervisory officers should have brought the matter to my knowledge. It is self-evident that that behaviour jeopardised the security and classification secret of that operation. The dangers that those officers exposed themselves to by that behaviour was paramount in terms of the whole exercise being revealed. And you don't need police discipline regulations to know that unauthorised sexual activity in the job when we were dealing with targets is wrong, not right. They knew that, they must have known that, but each one had circumstances which may or may not have put a different shade to it. I'm not saying that. I'm not suggesting that it justified the behaviour at all. But it should have come to the knowledge of Commander Ops.
Yes, thank you. Just in relation to that initial investigation by DCI Gray and DIHN 109, do you see it as problematic that officers from within the SDS themselves are the initial investigation, in particular circumstances where Stefan Skutt was likely to be disbelieved by them, given his particular circumstances that we've been through at length this morning in relation to the Skutt affair?
I understand your point, but what was the alternative? To bring in an outsider to deal with matters that were highly secret, when in the first instance it was to establish whether or not there was good cause for the allegation, whether it was true or not. So the initial inquiries, quite properly, in my mind, would have been conducted in-house by the managers in SDS. Once the information initially was achieved, and then there were queries about whether or not it should be follow a discipline route or the ill health route or others we've dealt with before. And I can't say, well, I don't recall, as I say, Scott, I don't recall anybody coming to me with information of that nature in respect of Scott.
It appears it did make its way to you, though, as we see from this minute, and you directed further investigation by David Smith and that you wished to be kept informed. David Smith was at the time one of your detective chief superintendents, is that right?
Correct. He was, in fact, I think, in charge of the SDS at that time as the chief superintendent.
Yes.
Yeah.
And you say in your witness statement that you're not aware of how the investigation concluded. You should have been made aware, at least in terms of this direction to be kept informed, shouldn't you?
Obviously.
You infer, because the file was, quote, put away, that the UCO must have been exonerated. Is that right?
I can't comment on that. I don't know.
Because isn't another possibility was that the investigation wasn't taken any further because of the paramount of keeping SDS operations secret?
That was a possibility. That would have been a consideration, yes. But that wouldn't have been taken at that level. That should have been taken at commander level.
Yes, and you don't recall it coming back to you? No. Had it come back to you, what would have been your attitude to such allegations at the time?
Well, I would have considered the whole circumstances of the initial investigation. I would have taken the views of the managers of SDS, including the chief superintendent in charge. I would have looked at the circumstances and come to a decision on what was the best course of action. I can't say now, and as I say, I don't remember these, but that would have been the logical course of action following an initial investigation in-house, passed to senior officers for judgment in-house, and then that should have come to me, and I would have then made a judgment taking into account the wider issues involved, including reputation, security, and all the other matters.
In relation to your interview with Operation Hearn about this topic, and the officer taking notes of your interview noted this, appreciates that if a person, brackets SDS, was vulnerable, he may have to, but would not be authorised. And in your Hearn statement, you say, I am conscious of the extreme pressures on the undercover officers, and it may well be that to maintain their deep cover, some officers may have engaged in sexual activity. I would not have condoned it. And that's MPS 0723255 at page 5. That rather reads as though you understand and almost sympathise with how a UCO could enter into a deceitful sexual relationship. Was that your view at the time?
No, that's your interpretation. I don't believe that I did sympathise. It was wrong, as I've said. It shouldn't have happened. And I've said before, and I say again, I am seriously concerned about the inclusion of Operation Hearn information into this inquiry?
I'm sure the chair has noted that. You do, though, seem to acknowledge that there was an obvious risk of it happening there.
Well, clearly there was a risk. It was a risk that, with all the other risks, had to be taken into account and judged in risk analysis. But yes, clearly there was a risk.
And you say there, I would not have condoned it. What does that mean in practice in terms of action that you would have taken had you become aware? Would the officer have been disciplined?
Well, again, I go back to the circumstances. There would have had to have been an inquiry into the issue, referred from initial investigation upwards to me. The likelihood, most likelihood, is the officer would have been removed from his role as undercover, because the risk of that officer continuing, if the allegation was true, and again, that would depend upon the veracity of the inquiries made into the allegation, that officer was in huge risk of discovery, as indeed the security of the whole operation was. So yes, it's difficult to give circumstances now which are hypothetical 30 or 40 years ago, but top of my knowledge, if that had been so, would have been removed the officer from his post forthwith.
We know now that during your tenure as Commander Ops, several undercover officers engaged in inappropriate sexual behaviour with members of the public. We know that HN 87 engaged in inappropriate sexual conduct during his deployment. We know that HN 10 Robert Lambert and HN 5 John Dines formed long-term inappropriate sexual relationships while deployed. You're aware of those
Yes.
officers now. You say you weren't aware of them at the time.
Not of their sexual activity, no.
No. In your inquiry statement, you say that you don't regard these incidents as a failure of oversight by senior managers. That's at paragraph 133. Why not?
Well, it depends upon the degree of oversight that one assumes to these matters. With the benefit of hindsight, it should have been more seriously viewed. But again, I come back to the fact that the concentration again is on the miscreants who've misbehaved, etc., etc. In terms of context and balance, all I can say is it is regrettable, seriously regrettable, that these officers went off-piste and engaged in that behaviour. But there are so many others that did not, and I cannot emphasise that enough in terms of balance, proportionality and context.
We know now that Bob Lambert disclosed his relationship to Tony Waite at the time. Tony Waite took no action. Isn't that a failure of oversight by a senior manager?
Certainly.
And you accept that he should have taken action?
I didn't know about that. I should have known about it, and it is a grave concern that if I had have known about it and done something about it, which I would have done, some of the angst and anxiety and distress as a result of their activity could have been limited.
Yes. That's one occasion which we know and you're aware of, that a disclosure was made to a more senior manager. You seem to rely upon that as an exception of failure in a manager taking action they should have taken. How can you be confident that that was indeed an exception and not the rule?
Well, I can't be confident, certainly as events have turned out. But at the time, my judgment, and I stand by the judgment, is that the Chief Superintendent was in charge of the squad in terms of its behaviour, welfare, officers' activities, etc., etc. And he should have brought that information to my knowledge. It was a failure of management that he didn't. But that doesn't, again, it doesn't assume that just because that, not just because, but the one incident that we should have known about, should we have known about all the others? Well, we didn't. And the fact is, as I've tried to explain earlier, these officers engaging in this untoward activity must have known that what they were doing was wrong. Why would they want the governors to know about it? Why would they talk about it? Why would they disclose those matters? I mean, I know in the cold light of day here, it seems impossible that we didn't have some knowledge of it. Well, I can tell you in the period that I was in charge, I had no knowledge of that sexual activity. And I find that distressing and almost unbelievable, particularly in respect of Lambert. But it happened.
In your statement, at paragraphs 131 to 133, you place some reliance on the officers' skills in subterfuge and their awareness of potential consequences of discovery of those inappropriate, deceitful sexual relationships. Aren't their skills in subterfuge one important factor in the reason why managers should have been very concerned to oversee these types of deployments very closely?
Yes, well, I've already said the whole essence of undercover work is based upon deceit, subterfuge, confusion, and it's quite clear that officers who had the skills and the ability to do that sort of work don't grow on trees. But it's also quite clear that they all knew that they had to stay within the boundaries of the law. But I've also explained the boundaries of the law as far as SDS was concerned in the first 30 years of its operations were very sketchy. And you don't need a law to say officers on duty should engage in unwanted sexual behaviour.
But you've accepted that there was an obvious risk that it could happen.
Well,
and wasn't there also a huge potential risk of harm?
Yes. If you put a man and woman together in the circumstances that these officers were actually acting under, it was clearly a risk. These officers were going to squats, sleeping on mattresses, rooms full of individuals. The context of exactly what happened has not been properly discovered by this inquiry as far as I'm concerned. The circumstance, we put those officers in that position. We must take the responsibility for that, not because they misbehaved, they should not have misbehaved, but we put them there and they behaved in the vast majority of cases properly, with integrity, with honesty, and not a little bravery. And I don't think that has been understood. But I do not excuse for 1 minute the behaviour of those officers that did transgress sexually.
In your statement, you say that you consider such behaviour would fall within the definition of discreditable conduct. Doesn't that rather understate the seriousness of both the behaviour and the impact upon the deceived women?
Yes, it does. But let's go to context again, Mrs. Simcoe. I am trying to illustrate the boundaries within which managers and officers work within the SDS were very close to the limits of the law. Indeed, there wasn't a law for covert human intelligence up until 2001. So we were judging on situations, risks and analysis of 30, 40 years ago. The world was a totally different place. The morality, the law, the environment, everything was so different in those days. And I only mention that because the judgment of those officers has to be taken into consideration under the circumstances that they were faced at the time, not in the cold light of day of this tribunal.
But you would still accept, as I think you have done today, that they would have known at the time that it was wrong?
Yes.
I said I would return to one of the recommendations from DCI Docker's review as a result of the SDS as a result of the Scut affair. And we went to the condition that you agreed should be imposed, limiting the deployment of single officers to exceptional cases. And you said in response to DCI DOCA's recommendation, and it's MPS 07269998 at page 5, and that's tab 39 of your bundle, sir. But I have emphasised that only in wholly exceptional cases should single officers be considered, and then only after prior discussion with the candidate's squad chief superintendent and commander ops. The rationale and the purpose of that condition goes to mitigating the risk of undercover police officers entering into deceitful sexual
Correct.
relationships, doesn't it? And so that was, again, acknowledged as a risk that needed mitigating at the time of this review.
Correct.
In your inquiry statement, you say that the rationale behind that such a condition was, you say you likely shared Eric Docker's view that a stable family background was an important anchor for undercover officers. Was that also part of the consideration? Excuse me. You say at the time that concerns about inappropriate sexual activity were not foremost in your mind at the time, but you've accepted just now that that was a consideration in relation to this particular condition.
It was a consideration, but when you have incidents like Lockerbie also on your desk at the same time, it may not have been a priority. I regret that. Obviously, I wished I'd have paid greater attention to it, but I did have a few other things on my plate at the time.
Yes, understood. And the particular mischief here was in relation to single UCOs, because that's what the condition refers to, that there should be a stable family background, and it should only be in wholly exceptional cases that single officers be considered. But wasn't there an acknowledgement at the time that even those in a stable relationship, such as marriage, there was nevertheless such a risk?
Well, it was considered, it must have been considered, but we got it wrong.
Other than this recommendation, did you take any other action to look at mitigating that risk at the time?
I can't recall. No, I can't recall. It was pretty comprehensive judgment and recommendation, and I would have wanted to have been satisfied that those recommendations were carried out, but in terms of how I followed up with any other additional stuff, I can't say.
In terms of other ways to mitigate risk, at paragraph 132 of your statement, you say that you don't know what additional training would have prevented these relationships, and greater supervision strikes me as problematic, because to be wholly effective, it would have required undercover supervision of the UCO. Were those the only ways you considered to mitigate such a risk, or were there other considerations?
They were part of the bigger picture, and as I've said before, in respect of oversight, to have limited or shortened the lines of command, communication between the UCO and the office, was part and parcel of dealing with that potential risk. I'm not sure, I can't remember whether or not that worked.
Thinking about it now, looking back, is there anything else that you consider could have mitigated such a risk at the time?
Well, I don't claim 100% hindsight, and obviously there would be other considerations that possibly could have been taken, but I'd say again, we were dealing with a situation 30, 40 years ago with very little support in respect of statutory or political intrusion in that, and I've got a feeling that should I have covered more? Possibly, I don't know.
In your witness statement to Operation Hearn, you mentioned there that you signed diaries on a weekly basis and that all the accounts and expenses of UCOs were strictly controlled. What was the purpose of signing diaries? Do you recall now?
Sorry, the purpose what?
Of signing diaries. In your Operation Hearn statement, you said that you signed diaries on a weekly basis and all accounts and expenses were strictly controlled. It's at page 5.
That was part of the general operational supervision in Special Branch. That was not unique to SDS. Every Friday, officers would submit their diaries with a record of their behaviour and activities of the previous week, including expenses. They would be signed off at Chief Superintendent level usually, but the SDS was signed off at my level because of the sensitivity involved.
And was that the case with your predecessor as well?
Yes.
Could further interrogation of administrative paperwork have been one way to look at mitigation of risk and discovery of deceitful sexual relationships, given how intertwined UCOs became into some women's lives, cohabiting, living together for years? Would that have been
it's possible.
A source of supervision?
It is possible. There are a number of scenarios one could raise now. Would you have done it then? Could you have done it? Why didn't you do it? Etc. etc. I accept that. But I come back to the point, we had to, and certainly Commander Ops had to operate on policy and operational issues in terms of priorities. And as I keep saying, Commander Ops had a wide range of responsibility and accountability, and some of the matters you're raising in the cold light of day here, which are important, and I don't decry that, but actually they may pale into insignificance slightly when you've got a Lockerbie.
You specifically refer to the relationship between John Dines and Helen Steele, and at paragraph 125 of your statement you say you weren't aware of that at the time.
No.
And you point out that her name and telephone number on a budget vehicle rental document was far from conclusive proof of such a relationship. But shouldn't paperwork of that nature have aroused suspicion, prompted further inquiries?
Possibly.
Were you aware of Operation Muscat at the time?
Help me.
Of course. This was an operation which arose as a result of Helen Steele's attempts to track John Dines down after he had withdrawn from his...
Whose operation was this?
It was an SDS and MPSB Special Branch operation.
And what's the date of this?
I can bring it up. It's MPS 0706718.
I've got a feeling this is after I'd gone to Cambridgeshire. I knew about the Dines case and it was on my watch, but the aftermath of the Dines case in terms of Helen Steele tracing him was after I'd left the branch, I think. I can't be sure, but I don't recall Operation, what was it, Muscat?
Muscat.
Muscat, I don't recall it.
No. As I said, the context of that was Helen Steele's efforts to track John Dines down after he had withdrawn from the field. Had you known about that at the time, if you had been in position as Commander Operations at that time, would something like that have aroused suspicions?
Yes.
And at that stage, what action would you have taken to act upon those suspicions?
Well, I'd done exactly the same as previously explained. I would ask for an initial inquiry by in-house officers in respect of what the issues were, the circumstances, then decide whether or not it needed further investigation, help or whatever. The Dines case was a particularly difficult case, and I don't know whether you want to ask me about that, but if you're not going to, I won't trouble you, but it was a difficult case.
I will come to later on the arrests
Okay.
of John Dines. Yes, it's on my list.
Okay.
So we'll maybe leave that there then and move on. Sarah, I'm conscious of the time. I'd be moving on to another topic. Is now a convenient time to break for lunch just a touch early? Or would you like me to continue?
If you're going to go on to another topic, would you rather have the break now? Yes.
Fine.
Then can you help me with one question before we rise?
Yes.
I referred to an answer, and I hope I've understood it correctly, that when you were dealing with the Scott affair,
Yes.
you said that there were crucial decisions that you had to make. I'm well aware that you can't now remember the detail of it, but you said that you had to decide what was best for Scott, what was best for the MPS, what was best for the Home Office, and what was best for the government. And you said it was detailed up to the Deputy Assistant Commissioner level and beyond.
Yes.
And beyond to whom?
Well, I don't know because I can't remember the specific detail, but in terms of chain of command, it would have gone from DAC Special Branch to the Assistant Commissioner Specialist Operations. If the Assistant Commissioner of Specialist Operations thought it worthy, and there was significant potential jeopardy here for all those you've mentioned, sir. That could have been referred up to the Deputy Commissioner, or more likely straight to the Commissioner because it was so sensitive. And I can't say because regretfully I can't remember, sadly, all the time that's been spent on Scott. I feel really troubled. Not because of the time that's been spent on it, but because I can't remember. But it would have gone, I think, in those circumstances to the Commissioner level, and if it didn't, it would be pretty senior under him.
Sir Peter Imbert, Commissioner at the time.
Ah, well, I would have thought almost certainly it would have gone to Sir Peter because he was a former Special Branch officer. He would have been trusted and understood the security of the operation of the SDS. Sorry, I hadn't realised that. Yeah.
Thank you very much. Can we resume at 5 to 2?
Yes.